this is Herbert Stryker, and I want to welcome you to a special TSCA 3030. So good morning if you're on the East Coast. Sorry, good afternoon if you're on the East Coast. Good morning if you're on the West Coast. And good evening if you happen to be in Europe or in Asia. So today we're having our April TSCA 3030. And the good news is that the taxes are not due in April this year, they're due in May. So, but in any event, so we know you have plenty of time to listen to this program. We have a very special program for you on perspectives on TSCA implementation. Next slide, please. What makes this program special? Well, we want to introduce to you our newest person in our environmental team, David Fisher. David comes to us from EPA. He was, just before joining Keller and Heckman, the Deputy Assistant Administrator for the Office of Chemical Safety and Pollution Prevention. You know, the Office of Chemical Safety and Pollution Prevention is the TSCA office of the FIFRA office. And so David, we're very happy and very proud to have David join us. He knows a great deal about the inner workings of EPA and the TSCA and FIFRA office. And I think his talk today will be very illustrative and informative. He also has extensive experience with the American Chemistry Council and a variety of other positions. I'm going to just turn this over to David, and I'll be back with you towards the end of the program.
Thank you, Herb, and appreciate that nice introduction. And hello, everyone. Delighted to have been asked to talk about to lead the latest installment of the TSCA 3030 program that Keller and Heckman has established some time ago. My bio is here on the slide, but there's additional information about me on the Keller and Heckman website. So, and my contact information is there as well. So what I thought I'd do today, I know we only have about 30 minutes or so, so there's a lot to cover, but I thought I would highlight some of the OCSPP priorities dealing with existing chemicals from the last 2 years of the administration. And those 2 years are when Alex Dunn was the assistant administrator for OCSPP. So she started in January 2019 and ended her term on January 20th, 2021. I joined the office around July 9th or so of 2019. So it was Alex Dunn, myself, and then Linda Clever, who were in the immediate office of OCSPP. And so I wanted to chat a little bit about some of the a subset of the existing chemical priorities during that 2-year time frame. And two of those priorities that I'd like to spend a little more time on deal with the OPPT reorganization that you all know about, no doubt, and then also data gathering under TSCA. Okay, so again, these are a subset of the existing chemical priorities. There would be others, but I thought these would be worth highlighting. You may recall that one of our priorities was to finalize the list of 20 low priority chemicals that was mandated under TSCA. We spent a fair amount of time ensuring that our rationale for selecting those 20 and designating them as low priority chemicals was absolutely rock solid, because we were afraid that if we were sued and lost, that invariably some of those low priority chemicals would become high priority chemicals. And that would mean that our baseline for risk evaluations would jump up. And that would have obviously catastrophic consequences to the Office of Chemical Safety and Pollution Prevention. So I was personally very much engaged in working with the teams to make sure the scientific rationale was absolutely solid. So I was delighted that we were not sued. So that was one of the few occasions where we were not sued when we actually expected to have been sued. So that was a great win for the team. And then of course, we spent a lot of time issuing the final and developing the final risk evaluations for the initial 10 chemicals. Administrator Wheeler was absolutely determined and expected OCSPP to come through for him and the greater EPA in finalizing all 10 before the term was over. And we did accomplish that very ambitious goal. It was not an easy task, as you can only imagine. But out of that very arduous engagement and exercise to finish the 10 initial final risk evaluations, there were lots of lessons learned. And so I also spent a fair amount of time with various teams within OPPT in particular to engage in initiating some of the changes that we would like to see in sort of the next generation, if you will, of risk evaluations. So the way we went about developing the initial 10 cannot be the way we're doing the next, that EPA is doing the next batch or forthcoming risk evaluations. The goal is to have, certainly was then, and I can't imagine it's changed since I've left the agency, but the goal is to have leaner, more readily accessible documents to stakeholders to try and mirror, if you will, some of the approaches that OPP itself has developed and embraced over the years. And so in addition to us coming up with a new generation of risk evaluation documents, and also I should say response to comments documents, because you may have noted that some of them were remarkably long, 300 pages, 400 pages of response to comments documents. Again, that is not sustainable going forward. So not only were we trying to come up with new generations of documents, but as I mentioned, we wanted to work very closely with OPP, because OPP, for those who were around and active in the mid-1990s when the Food Quality Protection Act was passed in 1996, that created quite a sea change within OPP. And there were a number of years in the early part of implementation of the FQPA where OPP staff were really struggling to adopt those statutorily mandated changes within OPP. And so they learned a great deal. And what I was very much promoting was this harmonization of approaches between OPP and OPPT so that OPPT could learn and get a jump start on some of the new approaches and better ways, if you will, of doing risk assessment, doing hazard characterizations that are part of risk evaluations, exposure assessments, et cetera. There was a lot of knowledge that OPPT could glean from OPP. So hopefully all those efforts are still underway. What will help is the actual physical movement of OPP staff from Potomac Yards to the EPA headquarters. That, of course, the pandemic threw that time frame off, but the goal still is, I believe, to bring everybody together in that one building. So OPP would entirely vacate their Virginia presence, and I hope that is still the plan. And then we also engaged in initiating risk management rulemakings for the 10 initial chemicals. As you know, the TSCA mandates that as soon as you finalize risk evaluation, you need to move immediately to risk management. And it has the astonishingly ambitious goal, or a mandated goal, of coming up with a proposed risk management rule within 1 year, which is absolutely remarkable time frame. I'm not sure where that 1 year notion came from. You have 2 years to finalize it, which of course is even is certainly as ambitious as the 1 year. Frankly, it's not a whole lot of time, and certainly not a whole lot of time to do that for the 10 chemicals. So the other priorities and these are the ones I want to spend a little more time on this afternoon. It was the priority of reorganizing OPPT to better align it with the new task, if you will, because it's not that new. It's 4 years old, but nonetheless, changes needed to be made within OPPT. And then I want to focus a little bit more also on the data gathering exercises that we were involved in when I was at the agency, and continue. Those involve Section 4 test orders, and then I want to talk a little bit about Section 8A and 8D rulemakings. Okay, so after Lautenberg, which was sort of immediately implementable, right? And there was lots of immediate activities that OPPT staff had to engage in, there wasn't really a lot of time to reorganize and restructure OPPT so that it could reflect the new TSCA, right? It was still looked like pre-2016 TSCA. There was a lack of clear staffing demarcation between existing and new chemicals. You had staff, frankly, doing both, new one day and then maybe an existing chemical another day. There was insufficient staff dedicated to existing chemical regulation, chemical risk evaluations. And then not enough staff focused on the data gathering activities under TSCA Section 4 and Section 8 that the agency was poised to engage in. So it became absolutely clear from the get-go that realignment of OPPT was necessary. It's a necessary exercise to more efficiently implement TSCA. And we were thrilled that the Administrator Andrew Wheeler was very much a proponent for us to do that. And we did it with gusto. It was a massive undertaking, all while we're trying to implement TSCA. But we thought, there's really never a good time to do a reorg, right? We all know that. It's always fairly unpleasant, but we were hoping, and I hope still that the fruit of our labors and those of the career staff will come to fruition through the exercise of having gone through the reorg. Now there are clear demarcations between new and existing chems. The staff are no longer asked to work on both. Clear demarcations between risk evaluation and risk management for both new and existing chemicals. So those remain, but I want to underscore that to the extent it was unclear whether staff were assigned to existing chemicals or new chemicals, it's crystal clear now, because a risk evaluation, risk management for existing and new chemicals are completely separate and distinct. Now, that doesn't mean that folks aren't talking and working with each other. And certainly doesn't mean that the risk evaluators are not talking to the risk managers. Because as I like to describe it, EPA engages in risk evaluation within the context of risk management, right? It's fit for purpose. You don't do risk evaluation just to do it. There are undoubtedly going to be risk management consequences. So you need the risk managers to be engaged to some extent. And as you may know, for the risk evaluation documents themselves, Chapter 5, the unreasonable risk determination chapter, that's pretty much in the domain of the risk managers. So there's a good example of how the risk evaluators and the risk managers work together in completing that entire risk evaluation document. So we also importantly created a data gathering and analysis division. So if you're wondering where to go to understand, who's working on prioritization or data gathering or systematic review, it would be folks within that division. That was not clear before. There are 5 branches for existing within the existing chemicals risk assessment division, otherwise known as ECRAD. Right, those 5 branches are dedicated to doing essentially all the risk evaluations. And I should note that there are 25 ongoing risk evaluations. The 20 high priority chemicals that you know of, plus the one, which is asbestos, right? Part 2 of asbestos, so that's 21. And then you have the 4 manufacturer requested risk evaluations. You have the ethanones, you have DIDP, DINP, and D4. So it makes a total of 25. So 25 risk evaluations spread out amongst 5 branches. It's an awful lot of work. But what was clear is the reorganization also created lots of new vacancies, right? So there was clearly a recognition that we needed more hands on deck. So we aggressively started recruiting scientists and also created an OPPT branch. One of the risk assessment division branches is actually located in RTP. And that was something, again, that the administrator was very much a proponent of, thinking that we might have greater access to new scientists who went to school and lived in the RTP region. So that happened, and that branch, as far as I know, is still fully staffed. And the aggressive hiring of scientists continue because there are any number of vacancies that still remain to be filled. Okay, so let me switch over to data gathering. You know where that's housed now, right? So let me talk a little bit about what those folks are doing. Okay, so during the peer review of the risk evaluations by the SAC, each of their reports, and certainly during the oral comments that they may have made, no doubt they raised the need for OPPT to fill data needs. I think just about every one of the SAC reports that were probably numbered in 100 pages thereabouts. So it's a great deal of effort on the SAC's part to draft those. But they almost always made a point of pointing to the need for OPPT to use its statutory authority to gather new data. Okay, so to acknowledge that and to implement that recommendation, we thought it would be best to start with one of the chemicals, and we started with one of the initial 10. The SAC report on PV29 made it crystal clear that new data needed to be gathered. We thought that would make a wonderful test case. We also thought that if we implemented the test order, we'd actually get data in time to finish that risk evaluation, and that is what happened. But ironically, PV29 was the first of the initial risk evaluations to be issued in draft. And then it was, again, ironically, the last one to be finalized. That's not what we anticipated, but that's what happened because of the need to issue this test order. But that was really an important exercise because the staff who had never written a test order for an existing chemical ever, right, because that was a new authority under Lautenberg, they needed to do it. They needed to try it and see how it worked and get used to that whole exercise. But what was crystal clear was that you cannot wait until a risk evaluation is underway to seek data. That's just not sustainable. We needed to do what we did with PV29 because those are the facts that we were, we were confronting. But going forward, it was clear that we needed to do any data gathering as early in the process as possible. Okay, so with that experience gleaned from PV29, staff then turned their attention to the next 20 high priority chemicals that were designated for risk evaluation. So you know that 9 test orders of the 20 high priority chemicals have been issued. I am assuming that test orders will be issued for the remaining 11 high priority chemicals. They were under development last year. I assume they are still under development, probably delayed with the transition with the new administration. But I would expect that those will be issued this year because the clock is ticking, right? Each risk evaluation is supposed to take 3.5 years. We are well into that 3.5 years. So the pressure is on to get those test orders out. But even if those test orders are issued, say they're issued tomorrow, and they would have been issued certainly earlier in the risk evaluation development process than for PV29, it will still be very challenging for staff to timely complete each of the 20 risk evaluations. So what will happen? The likely result is that the risk evaluations will just be organically staggered, if you will, and they will finalize at different times. That is just what will happen. That's exactly what happened with the initial 10. That will happen with the 20, actually the 25, frankly. Each risk evaluation is different. Each has its own complexities. You have different teams or branches working on different risk evaluations. There are different skill sets, expertise, etc. So just organically, things will just be finalized at different times, even though they all were launched at the exact same time, right? The scoping documents were finalized all together. So this is a really important point, and this was something I very much touted and was, part of my mantra when I was at the agency. So for new data to be developed, reviewed, and then integrated into the risk evaluation process, into any risk evaluation, test orders will need to be issued much, much earlier. So my mantra was the system needs to be front loaded. You cannot wait even until prioritization to do a test order, to gather new data. Because recall that the way TSCA is written, and this is another sort of challenging piece of TSCA, there are many, many challenges with TSCA. But one of them is, once you're aboard that prioritization train, if you will, you don't get off for maybe 6 or 7 years, because you go from prioritization to risk evaluation to risk management. And as I mentioned earlier, I highly doubt that the agency will spend any time on dealing with low priority chemicals. So every chemical that boards the train, if you will be a high priority chemical. So I know TSCA also allows for using test orders to gather data for prioritization, but I find that provision highly impractical. It simply does not make sense from a time perspective that the agency would seek data for prioritization. That I can't imagine that happening, frankly. It will be used for risk evaluation, not prioritization. Because frankly, for prioritization, the default is the chemicals are high priority, right? It's pretty easy to be classified or categorized as a high priority chemical. You don't really need new data for that. Okay, so the front loading is absolutely imperative. So that's hopefully, ideally, long before prioritization. That also means systematic review needs to occur much earlier in the process, because systematic review will help identify data needs. And as you know, TSCA has this quote unquote statement of need requirement that must be met. And each of the test orders speaks to that statement of need. And we spent a lot of time on that wording because we had to be right to withstand any sort of challenge. You don't ask for data just because you think you might need it. You need to really justify it. And that's reasonable. That's totally reasonable for the agency to have to go through that exercise. But there's no need for stakeholders to wait for test orders. You now know what a test order looks like. There are 9 of them out there. Just imagine that if your chemical is prioritized, you will probably get a test order that looks something like, or certainly could look something like, the test orders that have been issued. So I wouldn't wait. You could save money. You could save about $10,000 that you'd have to pay the agency to complete or develop or respond to your test order. There's lots of proactivity that I think TSCA envisioned that stakeholders could engage in now. I've been a real proponent for years now of proactivity on behalf of stakeholders. There's always something that can and probably should be done now versus later. One, you help the agency out tremendously, take some of the work off of their shoulders. And filling those data needs now would likely, and I think certainly could, at a minimum, influence when your chemical is prioritized. But Section 4 is not the only means for EPA to require data. As you know, TSCA created this Interagency Testing Committee, which convened in May of 2020 when I was at the agency. And they recommended adding 50 chemicals to what's called the priority testing list. I'll talk about that in a moment. The 20 chemicals, no, rather the 20 of the 50 are the chemicals undergoing risk evaluation. So those are the 20 high priority. But 30 are organohalogen flame retardants, all of them requested by CPSC. So it gives you a sense of some of the priorities ongoing at CPSC. They are very focused on flame retardants. So what happens with that list? Well, EPA routinely adds substances to the TSCA Section 8D rule when ITC adds substances to the PTL, which they have recommended be done. EPA will actually finalize that, and as the next slide indicates. So on this slide, we note that EPA had indicated in the fall 2020 Unified Agenda, which came out not too long ago, that it intends to add the 50 chemicals to what's called the TSCA Section 8D Model Health and Safety Reporting Rule. So that's an actual rule that's in the CFR, Code of Federal Regulations. So that rule is all baked. It's done. The only thing that EPA would need to do is add the 50 chemicals to that rule. And that rule already subjects chemicals that are added to it. It subjects manufacturers to submit to EPA a list and copies of unpublished health and safety studies. So it's actually fairly straightforward. Once EPA issues the proposed rule, it's finalized at the end of the 30-day comment period. So that's a pretty fast way of EPA adding chemicals to the AD. Similarly, EPA also routinely adds substances to the TSCA 8, what's called the TSCA 8A Preliminary Assessment Information Rule, the PAIR, otherwise known as PAIR, you may have heard of that acronym, when ITC adds substances to the PTL. So I also anticipate that happening if, in fact, EPA goes down the road that I've already laid out and suggested that they will, based on what they've published in the Unified Agenda. All of this was being worked on when I was at the agency. But just as an aside, as with the AD, the number of chemicals that can be added through that ITC process in any year is capped at 50. Under the PAIR rule, and again, all of this is already baked into the CFR, manufacturers would submit a report including production, use, and exposure-related information for those newly added chemicals. So I expect that to happen too. It certainly is in very much the realm of possibilities. But interestingly enough, what I just mentioned on the PAIR was not in the Unified Agenda. What was in the Unified Agenda, and this one was for spring of 2020, so a little bit later, earlier in the process than the AD rulemaking that I noted earlier. That the 2020 Spring Unified Agenda notes that EPA is developing a Section 8 rulemaking to add certain TSCA workplan chemicals to chemical-specific reporting and record-keeping rules. Okay, so that's yet another that's another rulemaking. It's different than the PAIR. EPA has done that in the past, not very frequently. They did it for nanomaterials not long ago. So if you're familiar with that, then something like that could also happen for work plan chemicals. And then if EPA does go down this 8A rulemaking road, they would likely collect existing information on hazards and exposures of chemicals from both manufacturers and processors. Okay, that's important. Processors would also be included. But under either sections 8A or 8D, from my perspective, and I think from the agency perspective too, it is unclear how much information EPA can really anticipate receiving. Past experience suggests a modest yield. And keep in mind, EPA has, those created dockets for all the work plan chemicals a few years ago to receive voluntary information submissions on all of those chemicals from whomever. I don't believe we received a whole lot of information. So one wonders how much you would get from this 8A or 8D exercise, but it's probably something that the agency will want to do so that it can demonstrate it's done everything it can to get data. Right, 8A, 8D, Section 4. Next slide. And those conclude my remarks. So thank you all very much.
David, that's terrific. This program is supposed to end in 30 minutes. However, exceptionally, since we have such a large turnout of people that are registered for this, I think we're going to go a bit longer and let you answer questions. If that's okay with you, David?
Absolutely.
This is the first time we've allowed this to happen during our TSCA 3030, which is supposed to be 30 minutes. So I don't know if you've seen the question and answer field. One person has asked whether it's expected that there'll be corrective supplements for the first-time chemicals. Yeah, I guess because of all the various criticisms that some of these risk assessments, early risk assessments, received.
Yeah, a very good question. It's certainly possible. And if that were to happen, so let's say there are supplemental risk evaluations done on some of the initial 10. So now we're talking 25 plus a few more.
Right.
So now we're up to 30. What I actually said to the transition team when I was at the agency, I said, if you're going to go in that direction, you need to understand that there's this concept of organizational assimilative capacity. There's only so much anyone can do. You know, OPPT can only handle so much. So I'm hoping that the new team within OCSPP is very, very careful about what they decide to supplement. And when they decide to do that, because, you know, as I said, there's only so much that can be done in any, you know, in any year or given day, frankly.
But David, isn't it true? I mean, the risk evaluation that finds unreasonable risk could be challenged during the risk management phase, right? After risk management rules.
After risk management, yes.
They have to be brought into court. And so doesn't EPA have to ensure that their risk evaluations are solid when they otherwise be subject to overturn or remand during judicial review?
Well, yes, and I guess that's what makes the ongoing risk of rather the litigation involving a number of the final risk evaluations so interesting, is whether or not, you know, the way or the policies that were adopted to that helped inform how those risk evaluations were drafted, you know, the so-called reg nexus, this concept of, you know, TSCA is not an all-encompassing statute. It has to work alongside Clean Water Act and Clean Air Act, et cetera. So some of the activities that one might have thought should have been embraced within the risk evaluation were deferred or referred, I should say, to other offices. If that is part of the challenge ongoing, I believe, and depending on how that goes, Herb, that would presumably inform the new look of the risk evaluations going forward. But I think right now, while all that's still being debated, I would caution against the agency adding supplements at this stage. Again, because the workload is so massive, unless they can absolutely ensure that it won't break the system. And that would be my concern.
Gotcha. So we had another question about the pre-prioritization phase. So if you recall, David, I mean, the agency issued some white papers. I think they had some short-term and intermediate plans or long-term plans for prioritization. And what's happened to those white papers?
Yeah.
Are they continue being worked on, or they don't seem to have been supplemented?
Well, my sense is folks are thinking at this juncture that the Workplan Chemicals, that list of Workplan Chemicals, the ones remaining that aren't already have been prioritized, will be the, you know, the bastion of chemicals drawn from for the next set of prioritizations. So I don't think there was really a sense that there was a need to delve into the whole concept of prioritization. You just look for now to the Workplan Chemicals.
Gotcha.
That'll keep the train running for a while.
Gotcha. So, and we still have hundreds of people that are still haven't dropped off. So I'm going to continue this for a few more minutes. So the ITC, I was surprised to hear the ITC had convened.
Yes.
I thought they had disbanded. So can you tell us a little bit more about that meeting?
Yeah. So that was one thing I was pretty involved in. So again, because data gathering hadn't been really thought much about, maybe just tangentially in the early days of TSCA implementation, there was perhaps no thought of reconvening the ITC at that stage. But when Alex and I were there, you know, we very much wanted folks to start turning those wheels on data gathering, and it was just inevitable that the ITC would need to be reconvened and drawn upon for their expertise to, you know, help us sort out which of the chemicals should be added. And so that, I suspect that will be an ongoing operation. There are some new players in the ITC, and as you know, TSCA expanded who gets to be part of the ITC. So I actually view it as hopefully a very productive outcome of our efforts at data gathering. So
that's fairly interesting. I want to talk a little bit about, the District Court of California Asbestos CDR case. So I guess the administration, the Biden administration has asked Judge Chen to reconsider his ruling there. Do you have any thoughts on that?
Yeah, as I recall, and I wasn't, I'd have to kind of go back a little bit.
Basically, the judge said that EPA had no choice but to amend the CDR to include more information on asbestos because the reasons why it gave it, basically EPA said that it already had enough information, and the judge said, well, you don't know what you don't know, and so you really have no choice. But the judge ordered the EPA to do it within a reasonable period of time, which the judge suggested was 90 days or something like that. And I think the Biden administration has filed papers with the court saying that that the court should revisit its ruling because Section 21 only gives the court the authority to order EPA to initiate a rulemaking, but not to set the conditions for the rulemaking, which the judge said in his order. So I think that's what that was about.
Yes, I know we had some conversations on that, and OGC was, as I recall, Herb, was quite perplexed by the ruling, and they know of Judge Chen because he's also the same judge who was dealing with the
fluoridation, yeah,
right, the fluoridation issue. So and so he's viewed as having some different perspectives, shall we say, on TSCA. So perhaps they were not surprised by such a ruling. So I'm actually glad they have asked for him to reconsider. I think that's a wise decision.
Great. So we actually, while you've been talking, we're not going to let you off because people are staying on the line, and we actually got more questions. So I hope you're okay with that, David.
Absolutely.
Again, as I said, this is a special TSCA 3030. It's an exceptional case. So someone says, how does EPA rationalize determining work exposure judgments in their chemicals reviews? Isn't that a function of OSHA? So, by the way, can you talk a little bit about the interaction between EPA and OSHA when EPA is doing a worker exposure assessment?
Yeah. So yeah. So I don't think there's any doubt that TSCA makes clear that workers are part of those that populate the populations to be assessed through risk evaluation. I mean, it's crystal clear. As you will see from the risk management rules, EPA will be floating this concept of an ECHL, right? An existing chemical exposure limit, which is sort of like a PEL, but likely lower because it's right, because it has to eliminate the unreasonable risk. But it's sort of modeled after the PEL, if you will. It's a performance-based standard, so it provides some flexibility to stakeholders to decide how exactly they will meet that ECHL. I mean, that's a concept that I think will emerge once the proposed risk management rules come out. How exactly? So if that were to come to fruition and the EPA actually promulgates and finalizes an ECHL, so I've been asked, so who's going to make sure that ECHL is met? Would OSHA do that, or would Office of Enforcement every now and then go venture into a facility? I think that remains to be seen. I mean, there is a memorandum of understanding that Alex signed before she left between OSHA and EPA, but it just involves implementation of TSCA Section 5. One could imagine perhaps a similar kind of MOU involving OSHA and TSCA Section 6. So that maybe that's the answer. Herb is using that MOU to help kind of understand what roles each of the agencies have.
That's actually quite interesting. We got another interesting question. Someone asked if EPA is going to do evaluations based on chemical categories. So, like let's say all PFAS substances, for example, rather than individually.
Well, let's see. So I would say look at the ethanones, right? That was a manufacturing request. That will be a single risk evaluation.
Right.
So that might be, I guess it's maybe a small category because they kind of appear together. So that's why that risk evaluation will be, as I recall, a single document. So that might be informative to that question.
That's helpful. Great. I had a question about use of reach data. So, as you know, that became a big issue during the PV29 risk evaluation, but in subsequent risk evaluations, EPA basically could only use the robust study summaries that are on the European Chemical Agency website as supplemental information. Has EPA given any more thoughts about how they can more properly use reach data? I mean, so for example, have been any more discussions with the industry about providing full study reports, or discussions with the ECA in terms of making it clear to companies that they can't simply use something in the EPA docket to satisfy reach registration requirements?
Yeah. So here's the rub. Just in general, when we were confronting, trying to entice stakeholders to give us data report, full data reports. So even we could not assure stakeholders that document would not end up in the public domain. Why couldn't we do that? Well, that document would be subject to FOIA. We could put a page, a cover sheet on that study, wherever it came from Reach or elsewhere, or, in the files of some stakeholder, and say, please, you'll violate copyright law if you distribute this, etc. But that seemed unworkable too. So as I recall we were never able to resolve that conundrum. How do you get data and keep it from getting out in the public domain? We just couldn't, we didn't know how to do that.
Well, I suspect that'll be a much larger issue if EPA starts issuing the 8D rules, right? Because I expect a lot of companies have reach studies, US companies have reach studies that they've gotten from their European subsidiaries in their files. So that's going to be, I think that issue is only going to exacerbate. I mean, I think the only solution is to ensure that Korea and Taiwan and EU don't allow people to use studies that originated in the EU and that just happen to be available because people can get them out of EPA's dockets. I think that's the only solution. A lot of people have asked questions about new chemical stuff, but our program next month is going to be on the upcoming changes on the new chemical program. So we'll defer that to next month. Yeah, no, I think this has been terrific, and I really, really appreciated your taking time to sort of chat with us. And we're, very pleased that you're with Keller and Heckman, and we expect that you will be participating in future TSCA 3030s, although they won't be sort of devoted to your sharing, your experiences at the agency and particular insight that you gained from there, but your thoughts more generally on different topics. Just want to remind people that the next TSCA 3030 is on May 12th. And as I mentioned, we are going to talk about new chemical program and the changes that are being contemplated from that program. The next Reach 3030 is the same day at 1:35. And, we now have the Reach programs every other month. And the OSHA 3030 is April 21st at 1 o'clock. And so, as already indicated, the next TSCA 3030 is May 12th. Next slide, please. And that's David Fisher, and you'll be seeing a lot of him. Anyway, I want to thank everyone. A good number of you stayed on for this additional 15 minutes. I hope you felt that it was worthwhile. Take care, everybody.
Thank you all.
See you next month. Bye-bye. Bye-bye.